So let's see if, okay. So welcome to Washington Arbitration Week. We are on our last session. This is our 24th panel. So we've had 23 panels during the whole week, starting on Monday, and this is our closing panel. And I believe that this is a panel that we've never had in Washington Arbitration Week. But before giving the floor to our moderator, Jeffrey Lehtinen, I would like to share with you an announcement. The sister forum of Washington Arbitration Week, which is the World Arbitration Update, has just released its dates for 2024. They are May 15th through 24th of 2024. And as Washington Arbitration Week, the World Arbitration Update is a whole week or more than 5 days forum that happens not only in Washington, D.C., but happens in various jurisdictions. The format is that of updating the international community on matters of international commercial arbitration, international investment arbitration, and public international law. And for that forum, we don't meet in Washington, D.C., or at least not through 5 days, but we actually meet in various jurisdictions. This year, we met in Mexico City, and there were also in-person panels in Washington, D.C., in Bogota, Colombia, in Spain, in Singapore. And the idea this next year will be to start in China and go through the 5 continents as before. The additional element that I would like to share with you is that its mission is twofold. One is to update on issues of public international law, international commercial arbitration, and investor state arbitration. And the other part of its mission is to decentralize international arbitration. So as to recognizing that there's wonderful counsel and arbitrators, not only in the main centers of international arbitration, the Paris and the New York, and even the Washington, D.C. and the London, but there are also a wonderful international community in Bruges, in Belgium, in Croatia, in Panama, in Africa, etc. So that's the other part of the mission. So with that, I will turn now into our panel of today's session, and we had been thinking quite a bit about dispute resolution in many jurisdictions, but what we had never had was dispute resolution within international organization or development banks. And the suggestion was made to us last year or this year, early this year, to share with the world what happens in development banks or what happens in international organizations when there are disputes inside because of projects that have been supported by the development bank, and there are claims of fraud or corruption. So this panel may address many things, including, for instance, projects in which the bank may be related to, or the international organization may be related to, but there may be claims as to things going sideways within the procedures of the bank. And will also eventually, I hope, also address issues that are very important for development banks and for international organizations, which relate to their functional sovereignty. So I'll stop there because I think that Jeffrey is way more apt to share with you the subject matter of the panel. And let me introduce him and say also thank you very much for your hosting, both to Jeffrey and also to Margarita Sanchez. You have been great supporters of Washington Arbitration Week, and we are very grateful that you're hosting us today here. So Jeffrey Lehtinen is a member of Miller and Chevalier's Chartered. His practice focuses on assisting clients with international and government investigations, regulatory compliance, and complex cross-border litigation and arbitration. Mr. Lehtinen has particular experience in counseling clients in regard to civil, criminal, and regulatory issues arising in their international operations, ranging from compliance strategies to mitigate potential risk to internal and government investigations. He has conducted internal investigations on behalf of audit committees and special committees concerning potential violations of the Foreign Corrupt Practices Act, anti-money laundering regulations, and economic sanctions laws, as well as allegations relating to potential accounting and disclosure irregularities in instances of potential insider trading and allegations of even sexual harassment and other workplace misconduct. Jeffrey has also represented multinational companies, financial institutions, technology companies, professional sports teams, international development banks, and their officers and directors in connection with investigations before the U.S. Securities Exchange Commission, the U.S. Department of Justice, the Financial Industry Regulatory Authority, and numerous other domestic and foreign regulatory and government bodies. And I'll stop there. We can go on, but I think that we have an incredible moderator and an incredible panelist today. Jeffrey, you have the floor.
Thank you very much, Jose Antonio. Can everybody hear me, first of all?
Yes.
Great. Well, good afternoon. Really appreciate the opportunity to be here. Thank you to Washington Arbitration Week for this opportunity. I didn't realize that this was the last of 24 panels. So typically I would say we save the best for last, but in this case, I'll just say we're the only thing standing between you and happy hour. So we're going to try to make dispute resolution as interesting and scintillating a topic as we can. As Jose Antonio said, we really are privileged to have a very distinguished panel today. And what we're going to be talking about is dispute resolution in the context of multilateral development banks and international organizations from two different perspectives. To just say dispute resolution in international organizations is a very broad and very ambitious topic. And they've only given us 75 minutes, so it's not enough time to cover everything. What we thought would be prudent is to really focus on two separate aspects of dispute resolution. One of which perhaps all of us are more familiar with, which is to say the internal dispute resolution mechanisms that exist within multilateral development banks and other international organizations, and has existed for many, many years, as you'll hear. And then the second aspect, which is what happens from an external perspective, when we're no longer talking about internal or sanctions proceedings, but rather we're talking about a multilateral bank or an international organization pursuing some sort of dispute resolution outside of the confines of their institution. That is to say, commercial arbitration, civil litigation, either as parties or participants to those proceedings, or as third-party beneficiaries or participants of those same disputes. So that is how we're proposing to organize the panel today along those two pillars, internal and then external facing dispute resolution. We really do want to encourage a dialogue or questions as we go through it. You can tell perhaps by the way I'm dressed, I'm not the most formal moderator in the world. So please, to the extent that people have questions or would like to provide comments, please feel free throughout the course of the conversation. I want to take the opportunity to, without any further background, introduce the panel because they are the stars of the show today. To my immediate left is Brian Patterson. Brian is Assistant General Counsel at the International Monetary Fund, the IMF, where he oversees internal and external litigation matters, employment law matters, and as well as the contracts work of the legal department within the IMF. So thank you, Brian, for being here. To Brian's left is Vanessa Duran Acosta, who has joined us from the Inter-American Development Bank. Vanessa has been at the IDB for over 12 years and currently serves as the Integrity Lead Specialist Litigation within the IDB's Office of Institutional Integrity. Thank you, Vanessa. Who do I have next? Yes. I have then to her left, Maria Lapatina, who is, I'm honored to be her colleague here at Miller and Chevalier. Maria is a counsel here at the firm, regularly advises multinational clients, including multilateral development banks, on complex cross-border litigation and compliance matters. To Maria's left is Jonathan Shapiro. John previously served as the Integrity Compliance Officer at the World Bank and is currently the founder and owner of Shapiro Advisors, LLC, in which he regularly advises clients on corporate compliance program design and implementation. And finally, but not last, all the way to the left is Tomas Solis, who is of counsel at the law firm of Greenberg Traurig. And Tomas's practice focuses on advising clients on public international law matters and representing clients in legal proceedings before international courts and tribunals and other international adjudicative bodies. I was worried I couldn't pronounce adjudicative, but I did. So here we go. So that's the panel. I want to thank everybody for agreeing to participate. We're going to start today by talking about internal dispute resolution, internal proceedings. And as we said at the beginning, MDBs and other international organizations have a wide variety of dispute resolution mechanisms available at their disposal, including a series of internal processes and proceedings to identify, investigate, and sanction potential misconduct by borrowers and other third parties. The World Bank has its own sanctions board, as we'll hear, and has for many years. The IDB has its own sanctions system and sanctions proceedings, as we will also hear. Those bodies, those deliberative bodies within multilateral development banks have their own unique idiosyncrasies, their own unique parameters for seeking to resolve internal proceedings. And so we figured a good starting point is to set the scene a little bit by talking from our experts in terms of what those internal dispute resolution mechanisms look like. So let me start with you, Vanessa. Vanessa, we want to talk about now the IDB and the IDB's approach to thinking about internal dispute resolution. Can you give us a sense in terms of what are the, broadly speaking, the parameters of how the IDB views the internal dispute mechanisms for resolving disputes?
First of all, good afternoon, everybody. Thanks for having me in this panel. That's an interesting question, very broad, but a message that I want to highlight is that, for example, in the case of the IDB and the MDBs party to the Uniform Framework for Preventing and Combating Fraud and Corruption signed in 2006, and all the MDBs party to the Cross-Department Agreement, which are the World Bank, African Development Bank, ADB, EBRD, as we follow a consistent and harmonized approach to both how we conduct the investigations and how we substantiate the cases before our corresponding bodies. In our case, we have the sanctions officer as a first instance when the Office of Institutional Integrity submits the statement of charges and evidence with evidence under the preponderance of the standard of proof is the preponderance of the evidence. When we submit the statement of charges and evidence, the first instance is the sanctions officer, followed by the sanctions committee in case of an appeal. But all of the NDBs follow general principles. For example, we have harmonized definitions of what it is a prohibited practice. We follow principles and guidelines for how we conduct investigations, how we sanction the parties. We also have principles on the treatment of corporate groups. So it's interesting to see how harmonized our practices are. Talking a little bit more about the MDB, the IDB, for the last 6-7 years, the Office of Institutional Integrity has implemented a strategy to place higher resources to the investigation and adjudication of high impact cases. High impact cases are defined as corruption cases, collusion cases, or cases of fraud during the execution of a program, which usually entail complex schemes of financial or technical fraud. In order to do that, the office implemented different steps. First, recalibrated the triage mechanism, which is the mechanism used at the intake stage to evaluate a case, to rate the cases and probably resolve cases with low triage score with alternative mechanisms, for example, procurement or other type of resolutions. Then implemented a strong approach to expanding the network of cooperation agreements with national authorities and international organizations to cooperate, to provide intel on cases on confidential basis. Also implemented proactive mechanisms of for the complaints, for example, through IRRs, which are the integrity risk reviews of portfolio or sectors, and also, and most importantly, as an alternative, as another way to increase the high impact cases, the negotiated resolution agreements, which require, in order to be eligible for an NRA, that the investigated party has evidence of either systemic integrity risk to the IDB group finance activities or significant prohibited practices committed either by the investigated parties or by third parties. With this strategy, we were able to increase significantly the number of high impact cases in our portfolio. For example, in 2016, 54% of our cases were high impact. In 2021, it was 92%. And these cases really entail, from a prevention perspective, an importance because they in a way, they yield the most strategic lessons for operations when it comes to implementing recommendations on how to mitigate integrity risk. From a litigation perspective, they're complex cases, highly litigated because they encompass usually complicated schemes with multiple parties, multiple jurisdictions. And from a sanctions perspective, these cases usually are resolved with imposition of a sanction that is not only a debarment, but a debarment with a condition, for example, the implementation of compliance program or a monitorship. So in a nutshell, something that's very complex, but in a nutshell.
Thank you, Vanessa, very, very helpful. Sean, I want to ask you if you can complement it from the World Bank perspective, given the number of years that you were there. In particular, I'd be interested for your views on the following, which is, we're calling these internal dispute resolution. Of course, they involve parties that are external to MDBs. We're talking about sanctions proceedings against borrowers, guarantors, or other participants that are outside of the MDB itself, but with respect to which the disputes get resolved internally. And so what I'd like to, if you can share, is the World Bank perspective on this, and to the extent that you can comment, what are some of the similarities or differences between how, say, a multilateral approaches these types of matters versus a more traditional national authority or enforcement authority.
Thanks, Jeff. And when Jeff and I were in the green room getting our hair done, before the meeting started, he raised this question with me, so I had some time to think about. First, I don't speak for the World Bank. I went there some years ago. But I do largely the same thing as I did when I was clients. So I think that the way one thinks about how the World Bank conducts INT, the vice presidency conducts investigations into the 5 sanctionable practices, which are fraud, corruption, collusion, coercion, and obstruction. And those are allegations which will take place in bank-funded or bank-administered projects. So there's a difference. A bank-funded project is traditional lending instrument or a grant. Bank-administered may be that it's the bank administering a multilateral trust fund. So where the bank's money is being touched, the bank has jurisdiction. Companies are not in privity of contract with the bank. The companies, which are the subject of INT investigations, are companies that have won contracts under projects funded by the bank, but that the bank utilizes the audit clause in the loan agreements, which gives them jurisdiction, okay? So INT has a robust worldwide investigative remit, and they exercise it. So not surprisingly, sometimes people will not adhere to the procurement guidelines and engage in one of the prohibited practices. INT, from my recollection and recent conversations, has an intake unit. They have regional teams which investigate these allegations. Sometimes a company will, especially a larger company with subsidiaries, et cetera, not be aware globally that this has taken place. It may be a remote subsidiary, a country office. And so once INT begins an investigation, sort of the flares go up, and eventually, in many instances, the company, how will we resolve this dispute, right? So we're going to resolve it through either cooperation, through the use of counsel to come in and try to figure out what's happened. As Vanessa said, there's an increasing movement towards a negotiated resolution. So INT will conduct an investigation. They will collect evidence. They will potentially send out a letter to the company under natural due process. You're being alleged to have done the following. What do you have to say about it? Often counsel will come in and they will begin a negotiation. How do we resolve this, right? And so often an effective modality is a negotiated resolution agreement. And what that does is it allows INT on behalf of the World Bank to demonstrate to the owners of the bank, which are countries, that they are safeguarding the bank's, the funds that donors have entrusted to the bank. And it's helpful because it allows an entity to mitigate its risk, and it allows INT or the World Bank to learn about particular schemes that are taking place, right? There's a difference between a traditional law enforcement organization and, say, INT or the World Bank. First of all, INT doesn't have law enforcement jurisdiction. INT can't investigate public officials. The closest thing INT can do, if there's belief that there's a corrupt public official, is to do what's called a criminal referral, which says, hey, country A, we believe that the laws of your country may have been violated, and here's the basis for that belief. You go forward and investigate. But INT or the World Bank doesn't have jurisdiction over public officials. It has jurisdiction over companies. And so with regard to the harmonizing that Vanessa was talking about, I sometimes use we, I can't get it out of my head. The MDBs will cross the bar. Anything over a year, sort of like a felony, a year and a day, is subject to cross debarment. But the bank isn't an enforcement jurisdiction. The bank is the World Bank, as are the other MDBs. They're development banks. They're stewards of funds that are being used to alleviate poverty. And you know, it sounds trite, but it's true. Build a better tomorrow in the developing world. So there is an interest in having properly skilled, properly managed companies execute bank-funded contracts and not being knocked out of those roles. And so the bank wants to say to those companies, we don't like the way you've been conducting your business. We have these procurement guidelines. Our evidence indicates that you have violated them. And so we're going to hold you accountable. We're going to hopefully come to an agreement where you acknowledge your wicked ways, and let's set about restoring your ability to work for bank-funded projects. But we need you to change the way you do that. And so from a sanctioning perspective, it first started with debarment. You go stand in a corner for 4 years and think about what you've done, right? The problem with that was, after 4 years, there's been no change to the behavior. And if it's a large conglomerate, so then the non-sanctioned entity just picks up where its sanctioned partner or subsidiary left off. Now it's debarment with conditional release, which is the default judgment. We're not going to allow you to work on bank-funded projects until certain conditions are met. Often, those are the imposition of an integrity compliance program that is effectively implemented, right? So what is it looking to do? Detect, deter, investigate, remediate those allegations which brought, or that conduct which brought the entity in front of the organization in the first place. I believe that we're headed towards the third generation, which is let's keep the companies working, but we're going to trust and verify. I would put to the MDB community, it's time for them to start considering that the default judgment should be conditional non-debarment, except for those cases of really pervasive fraud or corruption. It's antithetical to a development bank to take out good companies from bidding on projects, leaving less potentially scrupulous ones. You want to keep working? We're happy to have you keep working. But you're going to have a third party verify that you are in fact implementing a corporate compliance program. The companies will tell you, we just want to keep working. MDB should consider letting them continue to work, but under very strict controls.
So John, what does that mean? What does conditional non-debarment mean for people that are not sort of versed in the MDB lingo?
So a debarment with conditional release is you are no longer eligible to bid on bank-funded projects for a period of 3 years. And that period can extend unless the conditions are met. What are those conditions? And again, often it's the imposition of an integrity compliance program. Conditional non-debarment is, okay, we're shocked there's gambling at Rick's. We don't know how this happened. We believe you. We want to work with you. But we're going to mandate that if you want to keep working on World Bank or multilateral development bank projects, you can do so. However, a conditional non-debarment is like a suspended sentence, almost with conditions. You can keep bidding. We want to keep you in the mix. We want your skills. We want the competition, but there's going to be very clear, robust conditionality, which might involve the imposition of an integrity compliance program. And we're not going to allow you to report on all the wonderful things that you've done. You're going to be working with a third party to whom you will be subject to their scrutiny. and their training and experience, and that party shall be reporting to the MDB. So the entity keeps working, and the MDB can feel comfortable going to its board to say, we have this company that continues to work, but we are doing our level-headed best to ensure that the way they're conducting their business comports with the ethics and business practices that our bank owners mandate is a way that we would feel comfortable having them use the money.
Thanks, John.
Sure.
We're going to pivot in a minute to talk about privileges and immunities, but before we do that, Vanessa, I'm just curious, from the IDB perspective, you reference to this trend towards a higher incidence of negotiated settlements or negotiated agreements. And I just wondered, before we change topics, if you wanted to share some views on sort of the increased use of those types of agreements to resolve disputes.
So before getting into that, for the IDB, the baseline sanctioning, according to our sanctioning guidelines, is a debarment period without conditions. That's also changing a little bit. We're moving towards the imposition of debarments with conditional release, or the non-conditional debarment, which is at this point very rare in the IDB sanction system. And part of that is a lot of it because of the implementation or the increased implementation of NRAs. The NRAs are an alternative mechanism to resolving cases of prohibited practices. The criteria is assessed and evaluated by the Office of Institutional Integrity together with the sanctions officer, and the sanctions officer provides a range of sanctions and also a range of potential conditions that could be negotiated. The investigated party can enter into a negotiated agreement because, or it's likely favorable to them because they have the opportunity to negotiate within that range a less severe sanction, and they avoid the process of the full investigation and the full adjudication process. So in that sense, it's appealing to the investigative party to enter in these NRAs and to provide full cooperation. And that cooperation means that they have to agree on a statement of facts, which includes not only a clear description of their involvement in the prohibited practices, but potentially the involvement of third parties. So at the end of the NRA, there's always a sanction. It's not a process that would not end in a total of the hook kind of situation. But the important thing is that it's a less severe sanction and usually involves the component of monitorship, ongoing cooperation. And since we started doing the NRA so far, we have signed at least 10 NRAs, and it's becoming an alternative that is appealing to investigated parties and to OII as a useful mechanism of resolving these type of disputes.
Thank you, Vanessa and John. Before we move to our next topic, I want to see, are there questions that people have on the internal dispute resolution items that we covered? Okay. If there are not, stop us as we go forward. So we're now going to move into a second topic, which really is an important bridge between internal dispute resolution and the external dispute resolution that we're going to discuss. And that bridge is the concept of privileges and immunities. And I think as many of you know, who have dealt with multilateral banks or international organizations, within the last several years, the idea of privileges and immunities enjoyed by multilateral MDBs and international organizations has been a very, very hot topic of discussion. It's been a hot topic of discussion in the private sector, within the MDB space, as well as in the U.S. judicial system and other jurisdictions. But for purposes of the conversation today, we're going to look at it through the lens of U.S. jurisprudence. And in particular, there have been two very significant cases that have come out in the last several years that have looked at the extent and the scope of privileges and immunities enjoyed by international organizations. One is a U.S. Supreme Court case, and the other is a court case that was decided here by the D.C. Circuit Appellate Court. I promise you we are not going to give a lesson on the two court cases as if this were law school. But because privileges and immunities are such an important feature of thinking about dispute resolution in MDBs, we wanted to just talk about that for a second as a way to set the scene for a broader conversation about external dispute resolution. So let's start quickly with what the U.S. Supreme Court did in 2019. In 2019, the Supreme Court issued a decision in a case called JAM versus the International Finance Corporation, or the IFC. And many of you may know, IFC is the private sector arm of the World Bank. And so, Maria, I'd like to invite you, if you want to share some words on what did the Supreme Court do in the JAM case, and how do you see that impacting dispute resolution in the MDB and international space?
Just really quickly, this idea of immunity and there are a number of lists. Is that better? Sorry. So I was just saying, when you look at you start with the charters of these organizations that list the privileges and immunities that the organizations enjoy or purport to enjoy. And I mentioned that as a starting point, mostly because that language is pretty interesting and there are a number listed. And a lot of these court cases sort of focus on whether or not these organizations can be sued or subject to suit. But I wanted to highlight from the outset that there are other privileges that come into play when we're thinking about dispute resolutions and litigations and these other mechanisms, and to sort of keep the immunity, sort of the relevant immunity sort of at the forefront, because there are others that we should be considering as well. But returning to the JAM case, the question really in this case was whether the IFC could enjoy absolute immunity from suit under the IOIA, the International Organization Immunities Act. And the sort of the factual genesis of the case is that the IFC extended a $450 million loan and had a number of requirements under the loan agreement to ensure, for example, that there weren't going to be extensive environmental damage as a result of the loan and the activity under the loan, or the activity that the loan was financing. That didn't happen. There was environmental damage and there was environmental and social impact. And so a group of Indian fishermen sued the IFC for failure effectively to comply with the covenants under the loan agreement. The IFC tried to argue that it enjoys absolute immunity and made a number of arguments really about the purpose of these international organizations and the financing and the negative impact that extensive litigation could have on these financing projects, and ultimately lost in a 7-1 decision. The Supreme Court found that international organizations do not enjoy absolute immunity from suit, and they are granted the same immunity that sovereign nations would enjoy. So it's put into question the extent, just as Jeff was saying, of the immunity of an international organization, specifically under this idea of can this organization be subject to suit? But as I mentioned, there are other immunities and privileges listed in these charters, and some that we'll come back to as we talk a little bit more about dispute resolution. But for example, these charters also include language about the books and records of these organizations, and whether the books and records can be essentially subject to discovery or to production in a matter. And the language in these charters is very clear that that is absolute. So while we're talking here in the JAM case about whether or not these organizations are subject to suit, again, I just wanted to highlight that there are other immunities that come into play when we're thinking about dispute resolution that the JAM decision did not address.
And we're going to come back and talk about the JAM case in a minute, because you can imagine the implications that a Supreme Court decision has had for decades since the multilateral system had been established post-World War II. The multilaterals and the international organizations depended very heavily on the concept that they enjoyed absolute or near absolute immunity, both with respect to suit as well as their books and records. And now in 2019, you get a Supreme Court decision that comes out that says, well, wait a second, it's not quite right that multilateral banks enjoy absolute immunity. So we've seen some additional judicial actions that have taken place after that Supreme Court decision, and we're going to talk about that in a minute. But before we move off of the JAM case, Brian, I want to come to you, because the IMF is a different type of creature in many ways from the multilateral banks and other international organizations that we've been talking about. And indeed, Chief Justice Roberts, in the decision in the JAM case, draws a distinction between the language that exists under the charters of MDBs versus other organizations like the IMF and the United Nations. And in doing so, at least this is my read, essentially reaffirms this concept that the UN and the IMF, where there is explicit, clear language in their charter, reaffirms this concept of absolute immunity in those instances. I want to come to you and get your perspective. Obviously, you're a senior person at IMF. I'm not saying you're speaking on behalf of IMF. You're here in your personal capacity, but considering your knowledge of the institution, how do you interpret the JAM decision insofar as it relates to an organization like the IMF, and how do you see that sort of impacting the IMF going forward, if ever?
Thanks, Jeff. Yeah, I mean, the JAM decision is certainly an earthquake for all international organizations, including two who were singled out by Justice Roberts, the IMF and the United Nations, as having absolute immunity in their charters, so therefore not affected by the decision directly. But nevertheless, and we were very happy to see that language in there, and there's good reasons for the difference in the immunities of the IMF and the UN on the one hand, and MDBs on the other hand, and other organizations. And in the case of MDBs, of course, they were designed to raise funding in capital markets and are major players, major issuers in many capital markets. And so from the outset, it was felt sensible that they should be subject to jurisdiction in that, at least that portion of their activities, which are so important for them. Whereas the IMF, although it's not prohibited for us to raise money in markets, in 80 years we've never done so, never had to do so. All of our funding is public money, and all of our lending is made to national treasuries and central banks. So it is a very classic sovereign to sovereign activity, non-commercial, and at least in 1945, when we were first conceived, it felt totally appropriate that there should be absolute immunity for those sort of activities. And likewise, the UN's activities are quintessentially sovereign-like activities. But nevertheless, before JAM, the MDBs as well, and all other global intergovernmental institutions did not seriously contemplate that, absent an allegation of a waiver of immunity or outside of the actual waiver of immunity, they could be hauled into the local courts of any one country and especially not to answer for their activities on the other side of the globe, simply because they have an office in the first country. That is essentially the facts of the JAM case. And if the highest court in the country, more than any other, that is responsible for creating, sustaining the multilateral system for 80 years, says, yeah, you can haul these institutions into court. They can be hauled into Washington courts, they can be hauled into court in Moscow, in Tehran, and anywhere else. And it's a very sad outcome and an unnecessary outcome, frankly, because on remand, the district court and then the DC circuit threw the case out on another very closely related subject matter jurisdiction ground, which was that the gravamen of the complaint was not the decision-making or anything else that was happening at IFC headquarters in Washington, but rather, of course, it was the activities at the project site. And so the whole case ought to have been and could have been thrown out on that ground to begin with, but the Supreme Court wanted to address this issue. And just back to Maria's point about how important it is when you're dealing with international organizations or litigating against them, to look at their charters very carefully, because as mentioned, the IMF's charter is different, the immunities are different from the MDBs. The MDBs are different than other organizations. And then moreover, there's national statutory law in the United States, the IOIA, above all, and many countries have equivalent international organization immunities acts. And in the US, the IOIA sort of draws a middle ground, whereas the IMF and the UN have an absolute immunity, and the MDBs, at least interpreted by US courts, their charters have a kind of built-in waiver of immunity to some extent. The IOIA is a little bit of a middle ground where there's no built-in waiver, but then according to JAM, since JAM, there are now exceptions built in, the Foreign Sovereign Immunities Act exceptions. So there's many different layers that you need to pay attention to when
the JAM case, and people have commented on this a lot. And to your point, Brian, many people have said, well, why didn't the IFC just settle the JAM case? Right? I mean, why take the risk that you get a negative decision on your immunities coming out of the US Supreme Court? Which is a good question to ask. On the other hand, if you look at who the plaintiffs were in the JAM case, it's an environmental NGO that had essentially been representing the fishermen that claim to have been damaged by the project. And so it's, those are not your quintessential plaintiffs who are just trying to sue an organization for a financial benefit. They have much different outcomes in mind. And so one could reasonably say, well, even if the IFC were inclined to reach some sort of financial settlement, the plaintiffs were unlikely to come to the table absent some pretty significant concessions, non-financial concessions from the IFC. But it is interesting to think about how that case would have played out and how privileges and immunities would have or would have not been affected if that case had been settled prior to a Supreme Court decision. But take that as it may, post-JAM, as Brian said, there have been other cases in the wake of the JAM decision that have now looked at privileges and immunities in the context of litigation. And the second really significant case that we wanted to touch on briefly is a decision that came out of the DC Circuit, which is the appellate court here in the District of Columbia. And it's a case that sought to attack the immunities of the IDB insofar as it related to the IDB's sanctions procedures. And that's a decision that's known as Rosencrantz, which is named after the plaintiff in that case. And so, Vanessa, since you have the misfortune of being the IDB representative on the panel, would love to hear your perspective on Rosencrantz, and particularly how a decision like Rosencrantz post-JAM has caused multilateral banks like the IDB or perhaps others to think again about their litigation risk. And what are some of the things that we're seeing multilaterals and international organizations think about, perhaps for the first time, in an era where there's a realization that their immunities may not protect them. Absolutely.
So, well, that would be my personal opinion
Yeah.
because this is a highly complex and litigated field. So the sense that in this case, mainly what was questioned is that the plaintiffs allege some violations by the IDB on how the sanctions procedures were conducted, unfairness and other allegations in the process. So the IDB moved to request lack of subject matter jurisdiction in this case, asserting immunities under the EOI, the International Organization Immunities Act. And the plaintiffs allege that in this case, the commercial activity and the waiver that was mentioned on the office, the existence of an office apply. Therefore, alleging that the court had jurisdiction over the issue. But in this case, the court unanimously decided that the gravamen was to determine whether or not the sanctions procedures were appropriately followed. And that the court considered is not a contractual in nature type of dispute. It relates to a power akin to the power that sovereign states have to decide their handling of funds. And the reference that were made to the IDB's charter, the charter that was signed back in 1959 by 48 members, is that the members granted the IDB the power to implement appropriate procedures and mechanisms to safeguard that the proceeds of the loans are used for the intended development purposes. And this really shapes the conversation of the source of the jurisdiction of the IDB and other MDBs as the source that is not contractually linked. In that sense, the implications are that a lot of the traditional ways we have been thinking of conducting investigations, for example, everything that's linked to the audit clauses, the right and inspections, is not necessarily, if our jurisdiction is not necessarily linked to a contractual relationship, the interpretation and the rights and many implications broaden up in a sense that the jurisdiction goes beyond a contractual relationship.
Privileges and immunities. Good. Any questions? Going once, twice. I mean, I will say, and I don't know, John, Tomas, if you guys have thoughts on this. You know, you got a Supreme Court decision that basically found that, you know, absent explicit language in the charter, the MDBs do not enjoy absolute immunity. Then a couple of years later, you get an appellate court decision that upholds the immunities for the IDB in a particular situation. But from my personal perspective, you know, post-JAM, I anticipate we're going to continue to see a fairly significant amount of litigation coming the way of the multilateral banks, now that there is this opening coming out of the JAM case. And what I'm curious to get your perspective on, if this is a little bit off script, but I'll ask it anyway, is what should MDBs and other organizations be thinking about now? How should they be positioning themselves in sort of the post-JAM era where they may find themselves defendants much more frequently than they would have expected in litigation? What should they be considering? What should they be thinking about?
So I kind of just offer one. Thank you, Jeff.
Yeah.
Just for you to know, I was the one doing Jones and Jeff here in the green room. And we talked about this, but now I have a different, hearing what is being discussed here. So the World Bank and the IMF are UN specialized agencies. And as such, they have the right to request the International Court of Justice for advisory opinions. And all this that happens at the US level, how a US court interprets a US statute on the scope of on immunities, it's only applicable in the US. And that decision by the court may be wrong under international law. So I wonder, and this is just something I just was thinking about, whether the IMF or the World Bank had considered the idea of requesting an opinion from the court on what is the scope under current international law on immunities applicable to international organizations. And that would have general application. Every state would have to follow whatever what the court says. Obviously, if you do that, you run the risk of getting an adverse opinion by the court. But I was just thinking if that's something that and these institutions should be thinking about whether to do it or not, and have a final decision on what the scope of their immunities is.
Yeah. I'll just one quick reaction and then I'll come to you, John. In the Supreme Court case, there were several amicus briefs filed
Right.
that went in that direction, including at least one that was drafted by a very unsuccessful lawyer based in Washington. So we got killed, but we did try.
Yeah.
And there were many amicus briefs filed that actually went very much in line with what you suggested.
Yeah, because they're like just stepping out of the MDBs contest for disputes. I think there are two general categories of disputes involved in international organizations. One is the organization being a party to the dispute, which is one of the examples we've been talking about here. And the other one is when an organization decides a dispute, they adjudicate it. So for the first category, you have what we talked about here, an external private party. There is a dispute. Then you have an internal party, like employment disputes with the international administrative tribunals. You have disputes between organizations and their member states, between international organizations. And in the context of disputes between an international organization and a member state, the court has already issued advisory opinions finding that, for example, that the UN General Assembly is obligated to follow a decision by the administrative tribunal. There was another dispute where the court said, I think in 1949, early after the establishment of the court, that the UN could sue a member state if that state breached an international obligation that owed to the UN. And in that case, I think it was related to a UN official that was killed somewhere, and then the UN was trying to see if they could sue on behalf of that official and his family. And the court said yes. So when you're talking about disputes in international organizations, you have disputes inside and outside. And I was thinking that's based on these examples, I started thinking about, these institutions being UN specialized agencies, they could legally, they have the option. Whether politically they wish to do it, that's a different question.
I think that's probably a good bridge to our next topic, which is, as we question, please.
Well, thank you for educating us on external disputes with development banks. One idea that occurred to me, seeing the variety of development banks that we have here, or members of the World Bank Group, is their different functions in terms of or different types of organizations within the World Bank Group or other development banks, and I understand that there may be for instance, in the case of the IMF, greater levels of immunity than, for instance, what one might see with respect to the IFC. Is this something? Is that a correct impression in terms of depending on their constitution or on their functions, they would have less or more immunity? For instance, I'm thinking in terms of the IFC might have more dealings with private parties, and they might operate in themselves as a private parties, whereas somebody like the IMF might have a greater level of immunity. So, would you like to comment on that? And as a follow-up question, what about behaviors that or activity that you could construe as a really private or commercial? Would the immunity simply close to disappear, or the functional immunity would be simply really low? Would you like to comment? And this is pretty much a question to everyone, but no.
Who wants to go?
I don't know the answer, but I can give you a comment. In terms of functionality, what these institutions do is fundamentally commercial. They borrow, they lend money. So I think a functionality test as one that you would apply to a state, a central bank, for example, I think is different for these institutions than for a state. So transactions are commercial in nature, and they should be protected even so, I think. But I don't know the answer to your question.
Yeah, I mean, I think that it's very hard to draw a logical line other than like what I said, when the IMF and the World Bank were established at the same time in the same international conference in Bretton Woods, it was deliberately decided the institution that is dealing with central banks and treasuries will be absolutely immune. The institution that is going to have to raise much of its money in the capital markets will not be absolutely immune. So that was clear and I guess logical at the time. But of course, the IMF has lots of commercial activities in a pure sense, not the lending that we do to central banks and treasuries, but the huge expensive buildings we have in Washington that we constructed, largest renovation project in the city at the time, and $500 million in IT contracts and all kinds of things like that. So these are commercial activities, but they're absolutely immune. And it has not been our practice to waive immunity in any of those contracts, and it's not, the market has not required us to waive immunity. So maybe a different organization doesn't have the leverage or the financial security that can justify that position to a contractual counterparty. And they do have to waive immunity, like if you're the World Food Program, probably you do waive immunity in a lot of your contracts because you're not a secure counterparty for a company. But
if I may, I think the other thing to think about privileges and immunities, which these organizations hold extremely, extremely close and dear to their hearts, is it may not be a project base or commercial base that sort of puts that first arrow through the armor. It may be something as mundane as a staff dispute. So all of these organizations have internal justice systems, right? And we've talked about the US Supreme Court or the DC Court of Appeals. I think people should be thinking about the various courts in Europe that have specialized remits and jurisdiction. And I could see a case where a court in Europe would have a matter brought before it where one of the parties is a citizen of the EU or a citizen of the country where the court sits, and they say, I am an aggrieved party. I believe you have jurisdiction. So while we're talking about project-based finance or sovereign to sovereign, it may be something as mundane as a wrongful termination or something like that, where a court would look and say, under our national law, this would be a cause of action, and therefore we will hear the case. So tiny, could be the mouse that roars.
So I want to, in the time that we have left, I want to sort of pivot more in the direction of the external. So we sort of talked internal, talked about privileges and immunities as sort of this connector between internal disputes and external disputes. Now I want to focus for the last few minutes on external disputes. Brian, from the IMF perspective, you made reference already to some of the situations in which the IMF may be a participant in disputes. Because the IMF is slightly differently situated than some of the other organizations we're going to cover, can you comment a little bit about the circumstances in which the IMF has found itself historically involved in sort of external dispute resolution, how that has played out?
Sure, yeah, I would say three basic categories of litigation that we see, and even setting aside sort of project-related litigation that might occur, which we don't see. Of course, there's cases where we are acting offensively. The IMF board has decided to waive the immunity in order to vindicate institutional rights in the national court. Could be property rights, contracts, intellectual property, other things like that. And we do have an internal dispute resolution system for our employment disputes and for also lending disputes with the treasuries and the central banks. So we haven't had occasion, like MDBs sometimes would, to go into court offensively to vindicate its rights under a lending program. Second category we see more than any is cases where we're just defending the immunity. We're arguing about the presence of a waiver or the scope of a waiver, things like that. And employment-based disputes are definitely in that category because we do see in labor courts in Latin America and Africa and in European courts, occasionally former employees, aggrieved people try to take you to court asserting fundamental employment-based or constitutional rights, and we have to argue over immunities. So far, mostly successful, but there's certainly cases of other organizations that have not been successful. But then the final category, which is a pretty big one, and I think will continue to grow, is notwithstanding our absolute immunity, the IMF is still an interested party in a whole lot of commercial type litigation. Right now, there's these two cases going on in England where countries are either suing creditors or being sued by creditors, right? And the IMF's lending for advice is a feature in the complaints or the defenses. And so information that the IMF provided confidentially is evidence, and we want to use it as evidence. And so some of these other immunities, like Maria mentioned, the use of our documents and information come into play, and not always successfully. And then another interesting category, it's just, while we are not lending in the private sector, we're holding a lot of assets of countries, or we have preferred creditor status vis-a-vis countries, and other creditors to those countries might want to attach those assets or break up our preferred creditor status to improve their own position. So that kind of litigation happens a fair amount. Certainly, there's many cases in the DC circuit and as well as elsewhere involving Argentina over the years, various defaults by Argentina, and then all kinds of creditors trying to find assets all over the world, including lots of assets of Argentina at the Federal Reserve Bank of New York, including an account there related to their subscription to the IMF. And so if you're interested, you'll find cases on that and trying to attach that and more or less unsuccessfully. And creditors haven't had much success there. And then there's an interesting case now in the DC circuit known as Doe's versus Taliban, where we're waiting for a judgment where tort judgment creditors of the Taliban, right, victims of terrorism, have gotten a big judgment in a different court in the United States and are now going around trying to find assets to attach to execute that judgment. The Taliban is in de facto control of the government of Afghanistan, right? The government of Afghanistan has assets around the world, including at the Federal Reserve and at the IMF and bank and others. So we're defending attempts to attach those assets to take them away from the people of Afghanistan to satisfy victims in the United States. So that case is coming up.
That's right. Maria, I want to come to you as we kind of round out the session to talk about other situations in which MDBs and other international organizations have decided to launch proactive litigation. You know, if you were to do a search through the U.S. court system, there actually are not very many instances of multilateral banks or organizations launching proactive litigation. And in fact, they've been subject to a pretty significant amount of criticism in situations where they're lending billions and billions of dollars around the world, yet they seem to be trepidatious at litigating to preserve their interest and recover assets that have been either not repaid, misappropriated, or some combination. So I want to come to you and ask you about sort of your experiences, what you've observed in terms of situations where MDBs have decided to launch litigation, and what are the different considerations at play in those decisions. And Tomas, also, I know you have a lot of international experience, not necessarily in the context of proactive litigation on behalf of MDBs, but in other fora, so we'd also welcome your thoughts here.
So I would start by picking up on something that Brian was talking about, which is just sort of the inherent international nature of a litigation brought by an MDB seeking to recover. A lot of times we're talking about parties that are all over the world. So from the very sort of inception of the case and thinking about service of process, you're trying to figure out how to do that with a party somewhere else. And sort of at every juncture along the timeline or the trajectory of a case, they're sort of dealing with those cross-border considerations and implications, which I highlight that because it makes it a fairly challenging, complex litigation for an MDB to say, I'm going to try to recover a very significant amount of money to which I am entitled. But it's not an easy lawsuit. It's often a lot of parties, it's very international. And so just thinking about sort of the nuts and bolts of the litigation from the outset, as I was saying, you know, there is this international component, how to serve, how to find discovery. Discovery could be all over the world. Okay, I won. Now I need to recover the assets. The assets could be all over the world. I need to bring in counsel in multiple jurisdictions to help me find the assets, to help me freeze the assets, to satisfy these judgments. So, you know, I think it's really, you know, one really important consideration at the outset is to think about sort of that international footprint that these cases have, and how to sort of employ a very international cross-border strategy to be able to litigate, to be able to litigate, let alone successfully litigate, and then to recover whatever it is that you've earned or won in the judgment. And the other thing I would say, just to pick up on a theme that we've talked about a lot, is this idea of immunity and how these litigations can result in adverse decisions for the MDBs. I mean, obviously, we talked about JAM at the Supreme Court level, but you could also see a situation where an MDB brings a case, is seeking discovery, but now they're a party in a case, and other parties are seeking discovery from them. And you could very clearly see how the IDB, for example, could say, well, I have this language in my charter, you cannot get my books and records. And how a judge would react to that, to use a phrase that I think we've probably all heard in law school, the sword and the shield. You could see how a judge would say, you're asking for discovery, but now you're not willing to give it. And that could also result in sort of adverse decisions for these institutions. So I guess what I'm trying to say is it's a pretty complicated process, both because of the international sort of component and sort of logistically actually litigating, but also the risk of an adverse decision, especially when we're talking about these very valuable immunities, is at play and could really, you know, ultimately undermine the good efforts of the organization. So those are just, I think, a few considerations that come into play sort of early when thinking about litigating, and I think probably some of the considerations that make it difficult for an MDB or another organization to say, okay, I'm actually going to initiate litigation here, even if I'm very clearly owed something.
Tomas?
So we've been talking about disputes where the organization is a party to the dispute. I just want to give you an example where organization adjudicates the dispute that two parties that are not related to the organization are engaged in. And one example is the ICAO Council, the International Civil Aviation Organization has a council, which is in charge of deciding disputes on civil aviation. So if there is a dispute between two states, it happened recently, some states closed their airspace. I don't know if you remember, I think it was 2017, Qatar and Bahrain, Egypt, Saudi Arabia, and the UAE closed their airspace to Qatari aircraft for a couple of years, and Qatar decided to sue these four countries before ICAO. In that case, the way ICAO functions is like any other arbitration. There was an application filed. There is a secretariat. The secretariat receives the application, reviews it. If it's okay, they serve it to the other side. Then the defendant or the respondent state or states have the right to file a counter memorial. There is a reply, a rejoinder. So it's like an arbitration. The structure of the procedure is like an arbitration. That example is interesting, I think, because the council is composed of 34 states, members of the organization. And those member states appoint diplomats as members representing their states in ICAO. So it's basically a diplomatic, it's a quasi-judicial body, but the people deciding the cases, there might be lawyers, but they're diplomats and they're representing their state's government. So they're not really, they're impartial, but they represent the governments that put them there, basically. So it's a political, diplomatic, political setting. And because, not because of it, but yes, because of it, the Chicago Convention allows the state parties to the treaty, if they disagree with a decision by the Council, to appeal to the International Court of Justice. So I find this example very interesting, not only because it's a case where you can go to an organization to actually decide a dispute, but I think it's one of the very few examples where you have an appeal mechanism in international law. Of course, you have the appellate body of the WTO. And in the human rights system, you have different phases where you go. But in general, in international law, this is one of the very few examples when you can go to the ICJ and appeal a decision. And this has happened in two cases. It happened in 1972 in a dispute between India and Pakistan when there was a war between the two countries and the airspace was closed. And that led to a ICAO decision. The ICAO Council decided that they have jurisdiction to hear the case. So the losing party appealed before the ICJ. The ICJ decided that the jurisdictional decision was legally correct. So the case went down and the parties settled the dispute. Something similar happened in the case between Qatar and these other four states. The council decided that they have jurisdiction. The four states decided to appeal before the ICJ. The ICJ decided the decision of the council is correct. The case went back and the parties, the dispute basically was diffused. But I think it's an interesting example of, again, of how you can have access to other dispute settlement mechanisms that are not traditional arbitration or courts, where you can have disputes solved by these organizations. And in this case, as I mentioned, I find it interesting that you can appeal to the ICJ. And again, I think it's one of the few examples that we can find in international practice where that's permissible.
We've covered a lot of ground. Each of the topics that we've covered could be the subject of a semester-long course in law school or business school. So we've tried to do the best that we can within the limited time frame to cover a lot of complicated subject matters. But before we break, I just want to see if there are other questions. If there are not, we're happy to stick around and respond to anything on an informal basis. But again, want to thank the Washington Arbitration Week and thank those that have joined us late on a Friday, both here in person and virtually. And want to wish everybody a very happy weekend. Thank you very much.
Let me close off. I mean, I don't want to make longer, but I want to thank again Miller and Chevalier, because Margarita thought that this was going to be a low number concurred panel, the room is full. So this is a testament to the panelists, the organization, Miller Chevalier, and of course Jeffrey for a wonderful moderation. So thank you very much, and thank you for being with us on a Friday night where the sky is gray. And thanks to everyone who has been with us, and special thanks to the team that helped us put this together, Maria Lucia and Juan Pablo, back sort of in the monitoring room back in Extraordinary in Colombia, and thanks to all the sponsors and all the advisory board members, and to the Washington Arbitration community and everyone who traveled here for Washington Arbitration Week. The next Washington Arbitration Week is still after Thanksgiving in 2024. If you have a topic, like if you're walking to work on just a topic that comes to you when you're under the shower or getting your hair done by Tomas, then do let us know. We put it together. Okay? Take care and thank you.